My name is Dick Bowser. I'm on the faculty here at Campbell Law School, and on behalf of the law school and the North Carolina Center for Voter Education, I'd like to welcome you to this forum today. We do have the privilege of hearing from the two candidates running for the seat on the North Carolina Supreme Court, Judge Sam Ervin immediately to my left, and Justice Paul Newby to my far left. And here's how we're going to proceed today. Each candidate will have 5 minutes to make an opening statement of sorts to describe for you their respective qualifications for the office. And after that, I have a few questions for each of them. They will have an opportunity to answer those. And then after that, we will take questions from the audience. And so if you want to write them down, we will ask that you raise your hand, and we will get a microphone in front of you so that you can ask the question in such a way that everyone can hear it. All right, gentlemen, let's begin. Judge Ervin, first with you. Tell us a bit about yourself, how you see yourself as qualified for this particular office.
First of all, I want to thank everybody for coming today. It's an impressive crowd, and I'm glad to see the level of interest that's shown in this gathering. As has been indicated, I'm Sam Ervin IV. I'm currently a judge on the Court of Appeals. By way of biographical background, I was born in Morganton, which for those of you that aren't familiar with it, is in the western end of the state, about an hour east of Asheville. I went to the public schools there, then attended Davidson College, where I graduated magna cum laude, then went to Harvard Law School after completing Davidson and graduated from there cum laude. In 1981, I passed the bar exam and came back to practice in Morganton. I thought about offers that I received from a couple of urban firms, but decided what I really wanted to do was go back to the town that I came from and that I'd lived in all. From 1981 to 1999, I practiced with the general practice firm Birdby. Was at various times was Bird, Ervin, Wistman, McMahon, and Ervin. I should have had to answer the phone with that one. While in private practice, I did a lot of different kinds of stuff. Our firm basically handled everything except family law and providing tax advice. So I've tried lots of different kinds of cases, was regularly in the Superior Court, less frequently in the federal court, and frequently in the appellate courts, because I handled almost all of our firm's appellate work for the entire time I was in private practice. In 1999, I was appointed by Governor Hunt to the Utilities Commission. I gather there, at least in recent years, has been an energy law course taught here, so some of you may actually be familiar with the Utilities Commission. But for those of you who aren't, the Utilities Commission, even though it is housed in the executive branch, is defined as a quasi-judicial body. And it essentially looks like, if you were to go down and watch its proceedings, it looks like a Superior Court case with the trial court sitting without a jury. The members of the commission rule on evidentiary objections. The presiding commissioner rules on discovery issues. You hear testimony. You listen to witnesses be cross-examined. You make factual decisions. And at the end of the hearing, try to decide what you think the application of the law to the facts is. An order is issued that looks very much like an appellate opinion. Those orders are then subject to appeal in the appellate courts. So even though the Utilities Commission is not technically a court, it's described in the legal literature as a quasi-judicial body and looks a great deal like a court in terms of its operations. In 2008, I was fortunate enough to be elected to the Court of Appeals, on which I still sit. As you know, the Court of Appeals is the intermediate appellate court in this state. It handles virtually every kind of case heard in the trial courts and administrative agencies, with the exception of capital cases and utility general rate cases that go directly to the Supreme Court. While on the Court of Appeals, I've written somewhere north of 325 opinions and have helped decide at least 900 cases. I lost count several months ago, so those figures are not exactly accurate. I think if you look at the record that I've developed as a utility commissioner and as the judge on the Court of Appeals, I think you'll see, although the person themselves is not necessarily the best judge of the quality of their own work, I think you'll see several things about the nature of the work that I've done. First, I think it's would be fairly described as thorough. I have a well-deserved reputation for talking about things at length, and the reason for that is because I think the litigants are entitled to know what happened to them in the opinion that the court enters. Secondly, I think I've got a reputation for studying the record carefully, for understanding the law and making considered judgments on the legal issues. And thirdly, I think that people who have studied my record would say that I call them down the middle. I don't think that you can find any kind of a political or ideological bias in the kinds of decisions that I've made. I think I've made virtually everybody mad at some point or the other, and I think that's what you're supposed to do. So I believe that for all of those reasons, I'm qualified based on the 13 and a half years of judicial and quasi-judicial experience that I've developed, and the nature and quality of the work that I've performed both as a Utilities Commissioner and as a Court of Appeals judge, that I'm qualified to serve on this body, and have asked the members of the public to support my candidacy based on those and other reasons.
Thank you. Justice Newby, please tell us a bit about yourself and your qualifications for continuing in this office.
4 former Chief Justices, 2 Democrats, 2 Republicans. When can you ever get Democrats and Republicans to agree upon anything? 4 former Chief Justices who look at my work, very involved in the legal community, very involved with the Bar Association, very involved in teaching at various law schools. 4 former Chief Justices say that I deserve to be reelected. For the last 8 years, I've been privileged to serve on our state Supreme Court. I've strived to fairly and impartially and consistently apply the law in every case. I have a reputation of being a hardworking, thoughtful, thorough, honest justice. Because of the work that I've done, I've written more opinions than any other justice the last 8 years, almost twice as many civil opinions. Because of that, I have widespread bipartisan support from across the state. In addition to my work on the court, I've strived to be a good ambassador, including, of course, teaching here at Campbell Law School. It's nice to be at the law school with the highest bar passage rate of the state. Congratulations once again to the Campbell faculty and staff and the students. I have been chosen to provide continuing education to both judges, North Carolina Judicial College, as well as lawyers. I have written a book on the state constitution, co-authored with Professor John Orth over at UNC Chapel Hill School of Law. Of course, here I teach state constitutional law as well as appellate issues. I'm very involved in the Bar Association. My work in the Bar Association includes the legal education, civic education component. I go into the public schools frequently, as well as to civic groups, to talk about the importance of citizens being informed. Our state constitution reminds us of frequent recurrence of fundamental principles is absolutely necessary to preserve the blessings of liberty. Certainly I try to do that as being an ambassador for the court. I've been chosen to speak at Diversity in the Profession programs, and you might look at me and go, how can you add to that discussion? Well, I grew up in a small town, Jamestown, between High Point and Greensboro. My mother was a school teacher, my dad an hourly worker. I'm the first lawyer, first generation, or first lawyer in my family, and because of that, I go into the schools and I say, as you sit there now, if you will apply your God-given talents and abilities, then you too can perhaps become a lawyer, maybe be involved in state government. The Bar Association has recognized my work by giving me the Citizen Lawyer Award. The Bar Association has also recognized my constitutional scholarship by giving me the McNeil Smith Constitutional Rights and Responsibilities Award. I've also been chosen by the Library of Congress to help foreign lawyers and judges understand our legal system. It's the Open World Rule of Law program. We get foreign lawyers and judges that come here. I host them and teach them about the American legal system. So I've tried to effectively help folks in the United States and abroad better appreciate the framework of our country. Again, being an ambassador for the court. As I indicated, I grew up in a small town. First lawyer I ever met was through Citizenship Merit Badge as I was working toward my Eagle Scout. I tell folks only 4 years I ever spent out of state were the 4 years I went to Duke. And then I went to Carolina Law School where I met my wife who's a double Tar Heel, and started practicing law up in Nashville. I have a unique background for an appellate judge. I have a transactional background. I did real estate and business law. I was corporate counsel, and for almost 20 years before I became before I was elected to the court. I was an assistant United States attorney doing criminal work, but primarily civil work in both state and federal courts, primarily federal court, certainly handling appellate work as well as trial work, anything from personal injury to employment law to secure transactions, a wide variety of cases that have led me to write opinions I've written, and again, particularly twice as many in the civil area. Again, widespread bipartisan support. People from both parties who read my opinions say Paul Newby simply follows the law. The rule of law is my polar star. It's what I have exhibited the last 8 years and certainly my 32 years in the practice of law. I would ask for your support in my reelection. Thank you.
Thank you. We will now proceed to some questions. I actually have 3, and here's the first one. We'll start with you, Justice Newby. Does judicial philosophy matter to this office? And if it does, how would you describe your philosophy and how does it shape your work?
Judicial philosophy is very important. As I just indicated, my polar star is the rule of law. What is the rule of law? A lady justice is blindfolded. She does not see who comes before her, the richest, the poorest, the most powerful, the least powerful. Everyone is treated the same. I was teaching this to a class of 5th graders, and a little boy came up to me afterwards and said, "What's it like to wear a blindfold while you're at work all day?" And, you know, it certainly captures the importance of the rule of law. That's what sets us apart, sets our legal system apart. We're very fortunate to have that. I also believe very strongly in the framers giving specific roles to each of the branches. We have separation of powers, a balance of powers, if you will, among the branches. It is the legislative branch that debates issues in the public square. They make the law. The executive simply carries that out. And it is the function of the judiciary, one, to ensure that the legislature, the executive have not overstepped their bounds. So we take the Constitution, state and federal, compare what they've done to that constitutional safeguard of our fundamental rights, but also to enforce the legislation as intended, not as I perhaps wish they had done. One of the things I did when I took my oath of office was to put aside any particular policy views I might have. That's not relevant. What is relevant is what did the legislature intend, and that's what needs to be enforced. And if folks don't like what the legislature did, again, you debate that, you decide that in the public square, not before the courts. These are very important aspects of who a judge is with regard to their understanding of these fundamental principles. Another one that is so important, and we just take it for granted, 99% of the world say the government is here, we have power, we tell the people what their rights and freedoms are. That's wrong. The way it was set up is we hold these truths to be self-evident, that all are created equal and endowed not by a government or a constitution or a Bill of Rights, endowed by our Creator with certain inalienable rights, life, liberty, and the pursuit of happiness. That's what sets us apart. Our freedoms are here, and government's role is to protect those freedoms, and when certain parts of government, the legislative or judicial or the executive branches overstep that, then it is the role, the duty of the judiciary to step up at that point and say, you are encroaching on fundamental rights. You cannot, we, the government, cannot do that. These aspects of judicial philosophy are very important. The evidence of my record is 8 years, having written more opinions than anybody else. Go back, look at my opinions, read my opinions. One, for example, would be Beaufort County, where there was a dispute between the school board and the Board of Commissioners. Our legislature in the, since the 1800s has said that that dispute is to be decided by by jury, even though it's clear that there are many political considerations in that. So I wrote a concurring opinion in that. I said I disagree fundamentally that a jury should be weighing these political considerations. That's why you elect the county commissioners and school boards. But we had a case from the early 1900s that said that this framework was constitutional. And so that's why I wrote the concurring opinion that said, while I disagree fundamentally that a jury ought to be making those kinds of decisions, stare decisis requires me to recognize that this is what our prior court has already decided, and since I believe in the rule of law, following what our court, as well as the legislature, the Constitution, following those things, I'm not going to change this, but, this is a concern for me. The rule of law means a judge is willing to follow precedent. Certainly, when you look at my opinions over the last 8 years, that's what you're going to see. Again, 4 former Chief Justices who are engaged in the practice of law, who regularly read my opinions, say there's no political agenda, there's no personal agenda. All that you'll find in reading Paul Newby's opinions is that he believes in and follows the rule of law.
Thank you. Judge Irvin, same question to you.
All right. I agree with Justice Newby that one's judicial philosophy is very important. But I think you then need to say, or ask yourselves the question, what does that mean? All of us would say, I think, that what the role of any appellate court is to decide specific cases that arise from the trial courts based on the trial record for the purpose of determining whether the trial judge committed some sort of legal error. That's ultimately what an appellate court has to grapple with in each case. In doing that, the first thing you've got to do is understand the record. And I spend tremendous amounts of time looking at the facts to make sure that I've got them correct. Because if you try to make a decision on the basis of an inadequate factual record, you're going to make a mistake. The second thing you need to do is engage in a dispassionate analysis of what the law itself actually provides in a particular area. And it is sometimes relatively clear and sometimes not as clear. And so what you do is you try to determine what the legal principles are given to you by the framers of the Constitution, the prior decisions of the appellate courts construing the Constitution, construing statutory provisions enacted by the General Assembly, or implementing common law principles that were derived from our Anglo-American heritage going back to Great Britain, and then try to determine how those rules apply to the facts. In doing that, some of the things that I try very hard to keep in mind are the following. I think the greatest danger that's faced by appellate judges is to think of things as primarily intellectual problems. Most of the time, you wind up with a stack of briefs, a record, and a transcript, although we've gone to electronic transcripts, so they're not a stack anymore, of that type of papers in front of you in order to make your decision. You rarely see the litigants. You see the lawyers. Sometimes it's very difficult to remember that behind every case is a genuine human problem. And it's also sometimes difficult to remember that what you do, regardless of what it is going to have a real significant impact on the life of somebody somewhere, likely more than one. And so I think that invests the job of appellate judging and the job of any judging with considerable significance and requires you to take what you do very seriously, and I try to. The second thing we need to keep in mind is that the courts ought to be the one place in our system where everybody, regardless of whatever their station in life may be, whether they're rich or poor, whatever their racial background may be, whatever part of the state they come from, what other characteristics they may have, that they're treated equally, because the fundamental premise of all law is that you have a set of rules that's applied in a consistent fashion. And if you fail to treat everyone equally under the law, then you truly are living in a lawless society, because at that point, what's happening is that you're having a subjective series of decisions made by a bunch of judges without much grounding in what the fundamental legal principles that are applicable to that particular case are. So the second thing that's fundamental to my judicial philosophy is the notion of everybody being equal under the law. The third facet of my philosophy is equally basic. I think that political and ideological considerations have no place in appellate decision-making. The policy-making function is performed by the General Assembly in most cases as statutory law becomes more and more dominant in our legal system. It is not the job of a judge to sit there and say, oh, I think this is a great statute and therefore let me interpret it as broadly as possible in order to permit the benefits of it to flow everywhere. But on the other hand, to say, gee, this was a horrible piece of legislation, let's not do anything more than we have to in order to pass it. I think if you look at my record, you'll see that I'm able to handle all kinds of cases and come out in ways that are consistent with what the legal principles provide, that don't show any tendency to favor one type of party over another, but instead to try to call each case separately, individually, based on its own facts and based on the law. That's my judicial philosophy. If I'm elected to the Supreme Court, that's the one I would carry there. It's the one that I try to implement as a judge on the Court of Appeals, and before that as a utility commissioner.
Next question. Judge Urban, does the judiciary in North Carolina in general, the Supreme Court of North Carolina in particular, face any unique challenges in the next few years?
I don't know how unique the challenges are as compared to the situations faced in other jurisdictions. What I see, though, are several things that appear to me to be potential concerns on the horizon. The first is that we live, unfortunately, in a time of significant budgetary constraints. And so the court system, like every other part of state government, has had to retrench, has had to try to do more with less. I think that's felt more at the trial level than it is at the appellate level. But I hear stories in talking to my friends on the trial bench and in the bar about the impact of some of the changes that have had to occur as the result of budgets. The second thing, and I think the one that's more important, at least for my purposes, is a concern that over time people are perceiving the judicial branch as a more politicized body than it ought to be seen as. You look at the commentary about the United States Supreme Court, and it's written frequently in very political terms. You look at the commentary on other judicial races in other parts of the country, and you see an increasing politicization of judicial elections. You look at the history of what's happened in Alabama and Mississippi and Texas, and more recently in some of the upper Midwestern states, and there's grounds for concern. I don't think that politics has any place in the judicial system. I've said that 2 or 3 times, and I hate to sound like a broken record, but it's an important principle. North Carolina, about 10 years ago, appeared to be going down the road that many other states had gone down, in which we were seeing highly expensive judicial elections. They were getting to be more expensive with every year. My understanding is that when Chief Justice Frye ran for re-election in 2000, his campaign spent over $1 million. We went to a nonpartisan, publicly financed system of electing judges in this state because I think there was a concern that we didn't want to go where other states had gone. And that system's been in effect for about 10 years. If we are going to have a system of open elections, I favor that system. We could talk about other options some other time, but at least to me, it appears that we are going to be having open contested judicial elections for the foreseeable future. So we need to look at how should that system operate. The public financing system does 2 things. It requires you to raise a certain amount of qualifying money, and both Justice Newby and I have participated in the system and qualified under it. It requires you to raise a certain amount of qualifying money in order to demonstrate that you're a serious candidate. It then secondly limits how much you can spend to the check that comes to you from the public financing system and what you spend. As many of you know, in the election that we're participating in right now, there have been significant expenditures by super PACs. Those super PACs have already bought TV time. I've seen billboards bought by others, and there have been radio ads by a third group. It is not entirely clear what the motive behind these expenditures is, but there seems to be enough on the public record to suggest that there are political considerations behind at least some of them. I think this poses a very serious threat to the independence of the judiciary in this state. I think one of the fundamental questions that the public has to decide in this election is, what do you think of that process? The argument is, oh, it's a good thing because it gives people more information about the judiciary. At least from what I've seen so far, I'm not sure I would agree with that characterization of the informational component of some of the ads that I've seen, but I'll leave that to you. They're all up on the public media, and you can make your own determination. I think the most serious challenge that the court system faces going forward is simply whether we are going to try to remain a nonpartisan, publicly financed system at the appellate court level and a nonpartisan system at the trial level, or whether we are going to go down the road of politicized elections in which large amounts of money that appear to have at least some political basis are being spent, because if that becomes the norm, then I think judicial independence is at real threat, at real risk. Obviously, I don't think this is a good thing. I think it's something that voters ought to have in mind as they consider what choices they make in this election.
Thank you. Justice Newby?
Judicial independence. I have talked with numerous groups, and keep in mind that both Judge Irvin and myself have been endorsed by all kinds of groups, okay? And I've talked with certain groups about the whole idea of judicial independence. You can believe that judges should be elected, re-elected, okay, if they have performed the duties of their position, or you can say, I'm going to be outcome driven. Now, if you're outcome driven, very honestly, you're not in favor of judicial independence, because what you want to say is, if you rule a particular way, we will punish you for that decision. Now, it's just, broad framework. Keep in mind two processes. One says, here's a judge who's doing a good job. He understands his role as a justice. He understands his role as an ambassador for the court. Let's support that re-election. This election is about Justice Paul Newby and what I've been able to do the last 8 years, and whether or not I've done an adequate job. The greatest threat to judicial independence is going in and replacing a justice that's doing a good job for reasons that are because of name familiarity or for other partisan, if you will, reasons. Now, in 2008, on behalf of one of the judges at the Court of Appeals of the other party, I made a phone call, as I did in 2010, trying to discourage people to run against this person, because we should not be doing it for partisan reasons. Now, these judges for whom I made phone calls are registered in the different party, but I did it because I believed that they were doing a good job. In 2012, my seat is up. The former Chief Justice I've mentioned, Judge Eddie Green, Justice Bob Orr, great bipartisan support, tried to help people appreciate that I was doing a good job and that there was no reason to run against me. Now, people have to ask themselves and answer for themselves why somebody would do that. Now, obviously, the system's set up to where it can, but just because you can doesn't mean that that's a good idea. If you believe in judicial independence and you think someone's doing a good job simply following the law, then you don't do it simply because the person is registered in a different party. Clearly, that's what happened here. I'm registered in a different party, therefore I'm subject to an election. So, question number one is, I believe, look at the judge, the justice, are they doing a good job? Do they simply fairly and impartially apply the law? And do they understand the role, if you will, of being at the top of the judicial branch of government? If so, that person should be reelected. Now, yes, you can look at various endorsements. What do those endorsements mean? Some endorsements occur because of judicial process. They think this justice judge is doing a good job, they're fair and balanced. Other endorsements occur because people believe, oh, I think this judge is going to rule a particular way, okay? What I would like to see happen, okay, is first off, folks focus on my resume, focus on my qualifications, and then, if they want to, they can take Jimmy Irvin's resume, put it next to Paul Newby, and say, okay, which of these folks has the record that we would like to endorse? 52% of North Carolinians believe judges are appointed, not elected. 52%. Okay, it's easy to understand. We've only been electing judges since 1868. It takes a while for the word to get around, okay? Up until 2004, these races were clearly partisan, marked partisan. That did not mean that partisanship entered into the decision process, but voters had some information on the ballot, okay? In 2004 and since, there's no information on the ballot. It doesn't say who the incumbent is. Why? That's good information. The voter needs to know that. Statistically, what we've seen is that a third of the people don't vote for judges, roughly. Okay, that's not bad. You don't get extra credit for guessing on the ballot, okay? But of the 2/3 that do vote, half of those folks are playing some sort of name or gender game, okay? They haven't done their homework, and they get there and they vote. That's not good. That is a threat to the judiciary to have people electing judges based on nothing more than, oh my goodness, that's name familiarity. I tell everybody newbies have been in North Carolina since 1700. We just never did anything, all right? And Scooby-Dooby vote for newbie only goes so far. I mean, I need people to look at resumes, look at qualifications, look at my record, look at my broad bipartisan support. I believe if you do that, then you're going to see that Justice Newby deserves to be reelected to the Supreme Court.
Last question from me. Consistent with the Code of Judicial Conduct, what pledges, promises could you make to the people of North Carolina if you're elected to this office? We'll start this time with Justice Newby and then end with Judge Irvin.
I was asked by a reporter what role religion played in my being a justice on the court. My answer was this. I placed my left hand on the Bible and I raised my right hand. And I took an oath before all the people of the state of North Carolina to fairly, impartially apply the laws of this state and the U.S. government within the constitutional parameters of both the state and federal constitutions. And I said that, so help me God. That has meaning to me. As a Cub Scout and a Boy Scout, I understand. I grew up with the idea that you live your life based upon oaths. As a Boy Scout, I promised to do my best to do my duty to God and my country. I understand what that means. And for the last 8 years, I've been privileged to fulfill those responsibilities, just as I had the almost 20 years before that in public service with the U.S. Attorney's Office, where I also took an oath. When you look at my jurisprudence and who I've been as a justice on the court, you will see that I have faithfully adhered to that oath, attempted to live up to those aspirations each day. Again, given my background, I am very grateful for the privilege I have to daily be a justice on the state Supreme Court. And my pledge, if reelected, is to do exactly what I've done in the past. I'm not changing. I've got 32 years in the practice of law. I've got 8 years on the Supreme Court. I have my opinions out there. I've clearly stated my judicial philosophy, which is to simply follow the law. And if folks want a level playing field, each case to be decided on the merits of that particular case, then that's what I've done and that's what I will do. Any other consideration is inappropriate and it will not be of any influence to me because I decide the case that's before me fairly, impartially, consistently, concisely, so that practitioners across the state, lawyers, when a client walks into their office, they need to be able to say with some degree of certainty what the law is. Why, even law students, when they take the bar exam, need to know with some degree of certainty what the law is. That's the job of the appellate courts. That's what I've tried to do the last 8 years. That's certainly what I would pledge to continue to do if I have the privilege of being reelected.
Judge Irvin.
And I've also had the privilege, and I think Justice Newby and I would agree that it is a privilege to be able to serve the public. I've had the privilege to be able to do that for the last 13 and a half years, and it's the greatest honor of my life to have been entrusted to work as a utilities commissioner and is to work as a judge of the Court of Appeals. I guess I would, in answering this question, beg leave to differ with Justice Newby's attempt to frame the issue. The issue is not solely a referendum on Justice Newby's record. Contested elections, for better or worse, involve a choice between two candidates. And so I think the real issue that the voters have to address in this race is simply this: taking everything that you know into consideration. Everything. Who among the two competing candidates, because these are the only two choices you got, are likely to do the best job on the Supreme Court? That, to me, is the real question that the voters have to consider. The promise that I would make to the voters is this: there's been some suggestion that politics entered into my decision to run. and that's not so. I decided to run because I've long wanted to serve as an appellate judge and feel that I can make a contribution to the work of the state. And I think that I could do a good job if I did that. I think my record as a utilities commissioner and as a judge on the Court of Appeals, which is quite extensive, shows that I am fair, that I am impartial, that I don't make decisions on a political or ideological basis, that instead I make decisions based solely on the law and the facts. I resist having labels hung on me of any ideological nature because I don't think that can fairly be done. Yes, it is true that various endorsement groups make endorsements for different reasons. Justice Newby's talked about some of his. I've been endorsed, among others, by the North Carolina Association of Women Attorneys. I've been endorsed by the Academy of, I can't say Advocates for Justice to save my life. I've been endorsed by the Advocates for Justice. I've been endorsed by the News and Observer. My campaign has substantial support as well. And the reason that I believe that I have this substantial support is because folks know that I fairly, impartially, and without political or ideological bias decide the cases that come before me one at a time. That's all I've ever wanted to do. That's all I promise to do if I'm elected. It's been a great privilege for me to serve the citizens of the state. I hope I continue to get an additional opportunity to do that in the future. It's been great to be here, and I look forward to answering your questions.
Now it is time for questions that you might have. So if you have them, please raise your hand. We'll get a microphone to you, and you'll have an opportunity to address those questions to either one or both of the candidates.
Thank you. My question is for you, Justice Newby. I wanted to go back to the answer that the reference you made in the answer to your first question when you made that reference to Lady Justice being blind. And I just wondered if you could explain how that image and your answers today comport with the ads I've seen all over the state advertising you as the conservative candidate for the court. And if you could just address that.
Well, absolutely. Thank you for the question. Conservative simply means that you adhere to the rule of law. Conservative means that you conserve, if you will, the framers' intent that the judicial branch is not a policy-making branch. The judicial branch simply fairly and impartially applies the law. If you don't like the law, don't find a judge that might agree with you to change it, you go back to the legislative branch to do that. That's what it means to be a conservative. Some people say, well, I know in 2004, people said, well, are you going to be a conservative activist? I said, that's an oxymoron. It doesn't exist. If you're an activist, you can't be a conservative. A conservative believes in the correct balance of powers. A conservative believes, as Hamilton said in Federal 78, that the judiciary should be humble, that the judiciary should not be proactive, that the judiciary should exercise self-restraint. The difficulty that we've seen in our country is when judges enter the public square arena, in the public policy arena, and make decisions taking them out of the legislative area. I think that's wrong. I think that's judicial activism. And so certainly, again, as you've looked at my jurisprudence, you're going to see that I just simply apply stare decisis. Now, if you look at people who've endorsed me from both political parties, you're going to see an incredibly wide spectrum of political views. Well, why in the world would they endorse a conservative who's on the court? Because a conservative justice simply means I understand the role of the judiciary. And the role of the judiciary should be not activist, but simply follow the law. You want to see what happens when there's an activist court? Just think about 2 weeks ago with the referees in the NFL. Okay, it's all about the referee. Front page of the sport page. It's about the referee. It's not about the players. When you see a judge on the front page of a paper, generally speaking, something has not worked right. It should be about the issues that are decided, not the particular personalities of the judges. So that's what I have consistently, even since I ran in 2004, is I've defined what that term means. That means you respect separation of powers. Judicial branch is simply there to decide the cases before.
Other questions?
First, thank you, both gentlemen, for participating today. My question is this. Over the past 20 and even 10 years, we've seen technological and social and cultural advancements at a very rapid pace. How do you, as a judge and justice, interpret and apply a state constitution and many statutes that were written and adopted long before the world of 2012 was even dreamt up?
Judge Irvin, you want to take that one first?
I've actually had a chance to wrestle with that one relatively recently. I'm not sure whether this has gone past the Supreme Court, so I'm going to be somewhat guarded in what I say. But the issue that you mentioned in your question is one that I've wrestled with almost continuously since becoming involved in public life as a utility commissioner, because one of the first things that I had to do down there was to be involved in implementing the Telecommunications Act of 1996, which purported to deregulate the telecommunications industry. And over and over and over again, as the nature of the telecommunications industry changed while the statutory language did not, we had to wrestle with that very question and to try to determine what statutes that were passed in a pre-digital era or in an early digital era meant in the current time. And it's a difficult issue. The best example I can give you of how I've wrestled with that is a case that I handed down within the last year called Hill versus StubHub, in which we dealt with the issue of whether StubHub was liable for unfair and deceptive trade practices damages as a result of the fact that somebody bought a ticket to a Hannah Montana concert at about 3 times the face value. And we could talk about some other issues relating to that case, but I think I'll pass on that one and let you cogitate on that by yourself. And what we had to do was try to determine whether the Communications Decency Act, which at that point was a number of years old, how its provisions relating to interactive websites dealt with websites that were more current than that. And we ultimately determined through a traditional statutory construction process that the exemption for interactive content posted by third parties on interactive websites was in fact covered by that immunity, and that the trial court erred by granting summary judgment in favor of the plaintiff. More broadly speaking, I think this is an issue that is going to be before the courts for a while. To some extent, the legislature has begun to try to address this problem, and the principal responsibility for addressing it lies with the legislature, because only the legislature can change the underlying statutory language. However, when you have a common law decision, when you have a common law principle, or when you have a statutory construction issue, ultimately those all become common law type issues, in the sense that you have to look to prior decisions construing that statutory provision or applying that common law principle in trying to determine how to deal with that principle given the new set of facts that you have in front of you. And the best answer I can give you is that you do the best you can. You rely on analogical reasoning in the sense of relying on analogies. You try to see if you can learn something from the statutory language or the language of the prior decision. But ultimately, until the legislature acts to update certain of our statutes, it seems to me that we're going to have exactly the problem that you just described. It will be with us for a while, and the best example I can give you of how I've already dealt with it is my work on the Telecommunications Act. And more recently on Hill versus StubHub, I direct you to that opinion so you can see whether we botched it or not, and you can draw your own conclusions.
Justice Newby.
Certainly, as Judge Irvin's indicated, this is an ongoing challenge that we have. For example, 2 of the cases we had yesterday had to do with the issue of using digital displays with sweepstakes and digital games with sweepstakes. And the question was whether or not the statute that had been passed by the legislature would withstand constitutional scrutiny. I'm a judge, how constitutions will travel, federal constitution and state constitution. And so we look at the freedom of speech language in these constitutions, which clearly, when drafted, 1776, 1787, we did not have, any idea of this digital type of gaming and things like that. to try to discern what is fundamental speech. What are the implications, these fundamental rights that may be implicated? Has the legislature properly used its police power, or have they begun to step into the area of fundamental rights as protected by these two documents? You know, and whether it's, we've actually even seen this arise with regard to some of the laws from the 1930s and 40s about automobiles, and the legislature hasn't updated them to, for example, how many stop lamps, brake lights we call them now, stop lamps, should cars have? When can a law enforcement officer reasonably believe that there's been a violation of the traffic code? These are issues we wrestle with all the time. And, you know, as you look at my jurisprudence over the last 8 years, you'll see that we certainly try to discern what was intended both by the federal and state constitutions, what was intended by the legislature, and apply the laws accordingly.
Other questions?
This question goes to both candidates. Recently, people in North Carolina voted on a gay marriage amendment to the North Carolina Constitution. I'm interested to hear your stance on the issue, whether this would be a rule of law, you would follow the legislative intent, or whether this is an individual right, liberty question, should the issue come to the Supreme Court of North Carolina.
I'm going to actually take that one. In this way. In this way, the Code of Judicial Conduct, in my assessment, and you guys can correct me if you think that I'm wrong, I don't think...
I think you're getting ready to give the answer I was going to give you.
The Code of Judicial Conduct simply does not permit these two men to speak on matters that are not yet and have not yet been decided by them and by their courts. So that question they cannot answer. Next question.
This is for both the judge and justice. I've heard talking about upholding stare decisis. I wanted to know if you consider this to be a hard, fast rule, and if not, what would be your considerations in overruling the case?
I think to some extent, the answer to that question depends upon which court you sit on. Because the Court of Appeals on which I currently sit is, first of all, bound by the decisions of the Supreme Court, and secondly, bound by its own prior decisions. So that for the Court of Appeals, stare decisis is in fact a hard and fast rule, and we treat it as such. And you will see any number of cases that we write that cites a case called in re civil penalties, which is the case that says that we're bound by our decision. I think when you get to the Supreme Court level, the issue is a little bit different in that the Supreme Court obviously has the right to overrule decisions of our court, even if they didn't take discretionary review or hear it originally, or to overrule their own decisions if they come to the conclusion that those decisions were wrongly decided. And you can find language in earlier Supreme Court cases that say things like nothing is decided until it's decided correctly. The Supreme Court does say that. I think, though, that the experience that I had at the Utilities Commission in particular leads me to believe that that right is one which should be exercised with considerable care. One of the things that you will find when you have to go out in the world and practice privately or work in public agencies or in in-house legal offices is that you have to advise clients what to do. And the basis that you have to render that advice is simply what is the language of the statute, if you've got a statutory issue, or what have the courts previously said. And as I learned at the Utilities Commission, sometimes it's more important to know what the rule is than to know whether the rule was in fact a good one, because people need to know how to structure their conduct going forward. And so to the extent that the Supreme Court overrules one of its own decisions or overrules a well-established decision of the Court of Appeals, you create the risk of introducing fundamental uncertainty into the law perhaps upsetting established expectations and diminishing the predictability of the system. Stare decisis is there for a reason. It's so that everything isn't back up for grabs every time something comes up for decision. So I think you can probably tell from this answer that while I recognize the authority of the Supreme Court on rare occasions to overrule its prior decisions, I think that is a step that should only be taken when the court is completely convinced that the prior decision was incorrect and that no particular harm would be done by overruling. So that's a very long-winded answer to what you probably thought was a simple question, but it's not actually that simple a question.
Justice Newby.
I concur.
He always does that to me.
Well, I think we'll make that the last question. I'd like you to join with me in thanking these two men for being with us today, for appearing in this forum.